Hello everyone, I'm really glad to be here. Thank you for the introduction. My name is Oscar Verdoir, a PhD researcher at the School of Law and Criminology at Maynooth University in Ireland, and funded under the Advanced CRT program. Like all of you, I've also been doing research into the metaverse and the interesting opportunities and challenges it presents, specifically pertaining to copyright law and user-generated content. So first, in the context of my research, what is content? It is what we, as consumers or users, consume, use, experience, and which has traditionally been made for us by authors or other creatives or developers of some variety. This can include books, paintings, video games, databases, songs, and videos. This is content, and it presents us with a clear division between users and creators, those who use, consume, and those who create. However, as I will go on to discuss, should I use the microphone? Okay. As I will go on to discuss, this divide is not as clear as it once was. Creators put their works out into the world for us to use, enjoy, and experience, but they do want to see these works protected. That is to say, they want to be able to decide where their code, characters, art, or fictional setting might be used. This is where copyright law comes in. For those not familiar, an intellectual property right that guarantees creators certain exclusive rights over their literary and artistic works. This covers any and all works in the scientific and artistic domains, whatever their mode or form of expression. Authors and creators can therefore object to any unauthorized reproduction, distribution, or modification of their works. This is where user-generated content, or UGC for short, comes in and presents to challenge our notion of content. UGC is created by users, or consumers, rather than traditional creators. These are also referred to as secondary works that rely on something from an original work. Examples include fan fiction, which relies on pre-existing characters or stories, social media posts, which rely on a platform to enable the posting of the content, or video game mods, which alter the code of the game directly, or modify the game in some way. Now, while there are advantages and disadvantages to allowing, enabling, or simply tolerating user-generated content, it remains true that such works can infringe upon copyright, or may fall into one of its exceptions. The metaverse, as a concept, has the potential to be a new frontier for user-generated content, as it provides a new environment for many intellectual properties to intersect and interact. While the metaverse does not yet exist, we do have some ideas of how this could look like with video game examples like Roblox, Fortnite, and VR chat. The metaverse has been portrayed by many as the successor to the mobile internet. But the internet was open to all. With the privatization of the metaverse being a very real possibility, it remains up for debate who will own the rights to works, who the law will, and how the law will react to future user-generated content in the metaverse. Researching this while the metaverse itself is still in its infancy, and not a reality, will help prepare future policymaking, as if we act preemptively to discuss these issues, we may be able to regulate these issues early, rather than having to play catch-up as we have long done with the internet, which we're still regulating today. To discuss this topic, my research focuses on the following research question. To what extent does the current approach to, and application of, copyright law to UGC offer a suitable approach for UGC on the metaverse? To answer this question, I aim to first define the metaverse despite a lack of a common consensus definition. I will then discuss how users could contribute content and how present regulations apply, making use of comparative analysis of UGC across several forms of media through a series of case studies. Due to the sheer number of cases and relevance of the jurisdictions, my work focuses primarily on EU and US law. Finally, I am to discuss the need for new regulation, or whether our present approaches towards content are fit for purpose for the metaverse, specifically pertaining to the regulation of user-generated content. The metaverse also presents its own series of unique challenges. I've already mentioned the idea of a private metaverse, or several private metaverses, or metaversi. I've seen both used, I don't know about you. Which may present challenges regarding the licensing of works, the ownership of rights, or the tolerance of user-generated content. In addition, how user creators are treated in the metaverse in comparison to traditional creators will also play an important role. Finally, I also hope to discuss the possibility of a universal approach, or whether one will really be necessary. UGC presents challenges for more traditional and present forms of content even today, as approaches vary from jurisdiction to jurisdiction and from author to author. Some creators tolerate or even encourage user-generated content, while others try to shut it down immediately. And it is in this context that I aim to discuss the challenges that the metaverse may face, and also provide an overview of how copyright law has developed across different mediums of content, and how it may develop further in the future. And that concludes my brief presentation. Thank you very much for listening.
I'm going to leave the question to the end. Can you switch?
Yes.
Next slide. So next, we have Ernesto Edwards, who will be talking about your personal life. The Spielberg will see you now. Authorship and identity in AI-generated cinema.
Thank you very much, Sylvia. I'm so glad to be here with you today. I find it funny and entertaining. It shows how globalized we are, that I'm at Cervantes land speaking in English, so bear with me today. So your personal Spielberg will see you now. This is something that I've been wondering about, and something that actually Joe Russo mentioned over 2 years ago. I always kept this little piece of news there with the date, because it was April 24th, 2023, a few years after he had filmed The Avengers, the latest installment that he had done with his brother, and he predicted, okay, AI could be making movies in 2 years, it will engineer and change storytelling. I mean, it has happened in a way, but it hasn't happened in the way that he was predicting it over 2 years ago, because he said that we were going to start getting content that was generated and curated and produced specifically for the people that were choosing those things on the platforms, which actually it was a thing that Netflix and Black Mirror had already done with one of their episodes, John is Awful, where you had one character that suddenly starts seeing on Netflix her very life generated right at the moment it's happening. So the thing is, there is a question when it comes to AI that it started on who is the author, who is the creator when we are in front of an AI generated work, but it has actually turned into a question on what makes an author, and what is an author in AI, in the AI era. So the question on authorship and on protection takes in a specific term when we are dealing with film, in the sense that it presents as a prime example for us to discuss questions that deal not only with what AI is posing, but questions of contracts, questions of joint authorship or co-authorship. And when it comes to this specific aspect, we can see that we have different solutions from different countries that are actually, they were all thought of before AI came into action. The UK, which seems to be at least one of the forefront ones, it's from 1988. They weren't thinking of AI when they were writing the UK CDPA. They were thinking of computers, so they said, okay, there are computer-generated works, and we will treat the person who made the arrangements necessary for that computer to generate that work as the author. It was a legal fiction that is still used today, and one that might get an extension. We have the US with all the cases that you probably have been following if you are interested in IP law. We have Thaler and Permuter confirmed earlier this year. We have Concord, Anthropic, the music one, when it comes to inputs, not when it comes to outputs. We are still getting some cases in the EU. We'll be getting more later this year. Getty Images just started the trial this week. But we have the Czech one, SS Vital and Neshki Vilayan, and China, which seems to be at the forefront as well. But the thing is, The market is responding to all of this. Films are starting to use AI more and more. We just saw a couple of months ago Adrien Brody win an Oscar for his performance in The Brutalist, where he got a little bit of backlash because his Hungarian accent was actually modified with AI. So they were wondering whether his acting was truly his own and whether it was deserving of winning an award. That's when the Academy, Motion Picture Academy, said films made with AI can win Oscars. That's what the Academy said earlier this year, which goes to show that even if we haven't resolved who is the author, even if we haven't resolved where those works can be protected, because we still don't know what will happen in each jurisdiction, the market and the artists are starting to have a reaction, some against, some for it. There's this interesting analogy, I still remember when I first heard of it, when it comes to football, right? Dribbles cannot be protected. We have Lionel Messi there, in the sense that since you cannot actually choreograph them, you cannot know for sure how that movement when you're playing football is going to develop, then you cannot protect it when it comes to copyright, unlike, for example, a celebration by a football player or a choreography for a ballet dance. So what will happen when we actually get these films that Joe Russo predicted, where they are actually generated for each one of us, where you just input what you're interested in, the kind of movie you want to watch, the kind of content you want to see, all the information that the streaming platforms already have of you, and they generate that film. Will that be protected? In what sense? All the infinite possibilities will be protected, because we already know this age-old question when it comes to, okay, so let's imagine that there's a machine that is capable of generating all possible books. That hasn't happened, because the kind of power that it would need, it would be humongous. But what if it did? Would someone be able to register all that? And I think that we'll be getting some answers, probably not the ones that we want. That's why we have the walker races here, reminding us that this is just a race and we'll have to see how it goes. So thank you very much.
Last but not least, we have Gian Marco. Gian Marco Bovenzi. He'll be talking about AI-enabled crimes and AI-powered investigations, the role of artificial intelligence in Metaverse criminal ecosystems. He's from the Center for High Defense Studies, Rome, Italy.
Yeah. I think those AI-generated movies might be better than the most recent ones, in terms of Oscar at least, but besides the joke for movie lovers.
Yeah, at least some of them, yeah.
Something, yeah. Okay, I'll be real quick, 5 minutes, and this is just problem raising, of course. There's no solution in this little poster. I want to focus on the criminal aspect of the Metaverse. Here, AI is a little bit on the side, because it's not the pure aspect of the criminal issues associated with the Metaverse. So first of all, the Metaverse can be a new criminal ecosystem. Yes, it can. Why? Under several perspectives. Now, the thing is that it creates a third kind of environment, the Metaverse. So this means extended reality, in which the perception of the harm can have a new dimension compared to the digital perception and to the physical perception. This intertwines a lot with what has been said this morning, of course, in terms of neurosciences and effects on physicality. On 4 dimensions, the criminogenic, so the genesis of the crime, virtual to physical attacks, what we're talking about attacks that are carried out in a virtual environment and have physical consequences. So it can be perhaps virtual harassment that then can have effects in real life in the victim, psychologically and perhaps physically. And then the immersive virtual reality is the second component. Then this means that there are crimes, they're virtual to virtual crimes. When the virtual good is the object of the offense, it can be another typology of crime which is not as of today theorized as such. It's not, there's no legal provisions concerning like purely virtual crimes, let's say virtual trespassing, theft of a virtual object. Well, actually that might be, but when the object of the crime is virtual, there's some doubts about its legal qualification in criminal terms. Also the virtual physicality, it's another question. Victimogenic, because the perception of the victim is different. Well, here, of course, I'm not the correct speaker that we should talk with Mel or with this morning's speaker. What I can say is, of course, is that under a criminalistic perspective, the superrealism, so the enhancement of the reality and the social present and proteus effect, which are associated with immersivity and extended reality, can enhance the harm suffered by the victim in a virtual environment rather than in a purely two-dimensional digital environment. So we have the digital, we have the physical, and in theory in between there should be the virtual, but there's nothing which is sure as of today in terms of under a legal perspective. There's no regulation in this. Etiological, okay, well, the double perspective human avatar, both in terms of suffering the crime, the harm, and in terms of interactions between themselves, and also in terms of active of those who has committed the offense. Like, it depends on how the avatar will be qualified in the future, its legal status in terms of digital identity. Can the avatar be considered as an autonomous center of accountability, of liability? That's a big problem that has to be solved. In terms of criminal law, not sure about it, but in terms of civil law, there's another branch again. And then ethical and regulatory issues, of course, the need of a comprehensive framework. Now, okay, you can, well, the substantial criminal law parts, I've basically touched them already. So there's several kinds of also a taxonomy of crimes that can be drawn within the metaverse, like the pure cyber crimes, network and cybersecurity related crimes, unlawful accesses, that information, identity and privacy related crimes, organized crimes, financial crimes. Those are crimes that can be committed everywhere, physically, digitally, virtually. The only thing that changes is, of course, the possible amplification of certain environments, the issues in terms of investigations and other aspects. But then the new category of offenses, which is really the thing that I would like to stress the attention of, is the pure virtual offenses. Like the individual harm is triggered exclusively by the immersivity and the virtuality of the realm. So the virtual sexual harassment, virtual rape, theft of virtual property, trespassing a virtual space. How would such an offense be considered today? I don't know. According to the Italian criminal code, maybe we would call it like private violence. It could be called like a sort of harassment, but they would not be surely considered as harmful as the actual physical correspondence. So that's another issue. I'm done. In terms of digital forensics, we have a lot of problems when it comes to chain of custodies, of course, because the environment of the metaverse has a lot of differences compared to the digital bidimensional, two-dimensional environments. There's opportunities though, so in terms of law enforcement and investigations as well, enhanced police training, biometrics and identification, virtual questionings, well, you can read them. Those things that like the virtual lineups or replicas of crime scenes, trial and execution of sentence, that's an interesting thing. And there's evidence already somewhere. When it comes to virtual execution of the sentence, it's something that in Italy occurred in a couple cases, and also in California, I guess. So for rehabilitation programs of inmates, virtual reality can play a role in the metaverse in general. But of course, there's like tons to say about this. I'm open for discussion, for some boring discussion in front of Tempranillo or the Alicante also is good, right? So artificial intelligence enables crimes in terms of enhanced risks on deepfakes, synthetic media, LLM, NLP abuse, AI tools for financial crimes, and enhanced cyber attacks. While the investigation empowering, as also stressed in the previous panels, can have a lot of outcomes when it comes to AI agents and also tools for monitoring, telemetry analysis, prediction, pattern identification. Of course, all this has to come with strong, by design, measures in terms of bias risk. So we have to address the risk that there's no biases in the AI algorithms in terms of investigation and powering. And thank you very much for the attention. Sorry for the minute extra, and okay, I'm done. Thank you.
So we are exactly 7:30. I think we will have something ready outside, but since we're running late and everything, we will have a couple questions if there's anything from the audience. Yes, please.
I just wanted to tell Gian Marco that in the Netherlands there was a court case about the theft of digital assets, and that was clearly considered as just theft of physical assets. So it's clear that in all countries these kind of things are happening and are considered now also in court how to treat that. So that's now a consequence.
Yeah, though I have to say that cases are cases, law is law. So that is definitely a clue, of course, but until we would not codify something, it's tough to say that that will be for good. So I agree with you, and there's also a lot of cases also in IP law, of course, when it comes to, that's your that's your area of expertise. But until there's something saying, well, this virtual good can be considered as a physical good.
You can also differently. Our money, which is virtual. So it's always.
I think that most important and interesting thing, I think it's the when it comes to crimes against the person also, that's really even more triggering, because on goods I agree with you. Basically there's not really like why shouldn't it be considered as an actual good, definitely, though there's not a law, but still we'll get there.
Although sometimes people see it as fraud instead of actual theft.
Indeed, yeah, well, it depends
depends on the jurisdiction, but the two different types of crimes.
Yeah, definitely, yeah.
And clarify, these digital assets that the case in the Netherlands, they also have real world value in any sense. Like, you sell them and get real money? No. Oh, interesting.
But in a virtual world, you can earn them.
I see. So
it's something you earn, like you earn money in the real world when you work. In the virtual world, you can earn that by doing stuff that is valuable for that virtual world. So it's kind of your wage that you do stuff in the virtual world.
That's really. I mean, like Duolingo, you have to Duolingo every day, right? So it's almost like the XP sort of we earn at Duolingo. But interesting is like in Duolingo you actually combine things. Well, you can buy things and then you earn more. So maybe there is an association.
Yeah, often you can sell it in the virtual world.
And sometimes they are sold for real money in clandestine markets.
So I think that was probably, that might be some reason, because that is a real world market, where the cases you're talking about transplanting the virtual world, that's more difficult to translate.
Also the thing is, the good, or like in this case, the file or the NFT or whatever it was, is the object of the crime, but is not the right that is protected. The right that is protected is the right for a person to have something, and to have something that can be valuable as economically valuable. So it doesn't matter if it is virtual or real. The important thing is that it's an asset, and as an asset has economic value, or moral value, or whatever as a value, but this is just the object. This is the criminal theory, the general criminal theory.
It depends on the harm that is caused. Like the point is not criminalizing or not, because we should criminalize. But how? Like does all this which intensity, which level of harm are we talking about? Like, is it just a digital good? Is it just an asset? Or it's about, it depends on the intensity, and there's a lot of parameters which just, I think, raise questions. To make a crossover with his presentation, there's this movie, Ready Player One,
Yeah, it was
which
there.
is, indeed, which is the example of how actually assets in real life do not really, metaverse assets in real life do not have a necessarily a correspondent, but in the game, which is called again with what's the name of
The game itself.
the realm, those people live like for life in there, so everything counts in that, just in that kind
Yeah,
of.
they live in dumpsters, most of them, in real life.
Yeah, in real life,
Well, let's hope society doesn't get to that.
no, hopefully not, but who knows?
So I don't look a lot at like sort of content and IP governance and that sort of thing. So just a question, I guess, for the first two. Have you seen much in the way of issues around the co-creation or collaboration or production of things? We usually see this stuff discussed with like a person does something or a user does something and then the platform does stuff and how those sorts of things resolve. Or a lot of discussion tends to be within the infrastructure of the platform. But is there any discussion around joint user creative sort of stuff? Like we work together to collaboratively build something and then trying to unpack that kind of thing. So it's kind of a user-to-user challenge versus...
Generally speaking, it's already technically a non-traditional form of content, so the law is kind of murky on that in and of itself. Like, I don't think we have, I can absolutely be corrected, but I don't think we have any any direct legislation pertaining directly to user-generated content. A lot of it is either platform policies, like YouTube, for example, how they treat copyright infringement there. They treat that locally. They don't bring it to court per se. They use notice and takedown. Or, for example,
Steam's workshop.
Yeah, Steam Workshop, for example, if there's an issue there, Valve handles that locally instead of having to necessarily reach out to courts, and it's all handled quite locally. And a lot of user projects are actually group endeavors. It's like any project nowadays, to quote the example of mods, almost no one makes a mod on their own nowadays, just like no one can make a game nowadays, or very few people can. It's not impossible, but only the few, so to speak. So as to, I've talked a bit in circles, I apologize. As to whether we have anything on collaborative user works, not that I'm currently aware of, but I doubt it would be treated any differently, like if we had proper regulation in place. Depending on how we would treat user creators, it would then change how we would, it would then reflect, I imagine, how we treat collaborative works that are traditionally created, if that makes sense.
I think that's right, except I think the platform's in between that too. So
Yeah, the platform's always been in between. It's always been the whole who gets credit and who actually gets to say, I made this, while the other person may need to sit in the shadows. Yeah.
No, you're interesting as a computer scientist, definitely. Stack Flow was a few years ago. We never start from the beginning, and now just I open ChatGPT, I want to do this code. I definitely start from there, not writing every single one myself.
It is a whole other mess. I'm not even going to get into that.
I have a question for Oscar. It was quite interesting, and also your questions were also my questions. Mm-hmm. But now I want to hear your answer if you have some, because I'm just curious to know if it's the same of what I think.
Right. Now I'm only 2 years into the PhD. I still have a lot of reading to do and a lot of research to do, going case by case right now. But pertaining to the general answer, sort of, I think the systems we have in place are technically fine because they have been technically fine across multiple evolutions. When we first got the internet, when we first got video games, things changed, but we always relied on older law. It's just that when we look at, for example, a lot of challenges the modern internet is facing, there are more specific small regulations that have to be considered, or relating to privacy as well, and that may not necessarily apply as well in the metaverse as it does to the internet. Or we need to seriously amend all that legislation, which amending the entirety of the GDPR sounds like a fun time. think we can definitely use a lot of what we've used in the past. We're not reinventing the wheel, we're not recreating copyright law from scratch, but I think a few small changes might have to occur, specifically for the user-generated content side of things. But that's kind of a sentiment that's shared amongst a lot of authors on user-generated content, that things need to change to incorporate user-generated content better, to have more adequate exceptions for copyright for certain specific examples, while, well, potentially showing some of my biases there, but while simultaneously still allowing authors to obviously control the content they create. Does that answer your question?
Yeah,
Are we on the same page?
We can discuss.
We will discuss again.
Because it's quite boring.
Do we have one last question, or we're ready for
Yeah.
a break? Okay, thank you very much. Another round of applause.